So we're talking today about the legislature as an institution, as opposed to the process, which will be a later topic, i.e., how the three forms of legislative measures make their way through the California state legislature. Instead, our focus again is on the legislature itself, as an institution, as the third branch of government, or perhaps first under the Constitution found in Article 4, five being the executive branch, and six, of course, being the judiciary here in the state of California. Um, there's a fair number of roles for the California legislature. Obviously, its chief role under Article 4, Section 1 is the lawmaking power. So, of course, it delves deeply into state level public policy issues, no matter how large or small over the years. Also, as one of the three branches of government, sort of like its federal counterpart, the U.S. Congress, it provides a series of checks and balances to be a co-equal branch of government, along with the executive and judicial branches of state government. It also maintains some significant oversight and investigatory powers, although, frankly, one of the criticisms lodged against the legislature is the lack of engaging too much in those activities, whereas their main focus is on lawmaking itself. And one of the most critical roles, of course, for our state legislature is the adoption in conjunction with the governor of the state budget, now roughly a $300 billion spending plan. So, as with the U.S. Constitution and the three branches of government, Article 1 under the federal level is the legislative branch. Article 4 in the California Constitution is for the legislative branch. There are 28 sections, although in the beginning sections of Article 4 is where it deals primarily with the legislature as an institution, and some of the later sections deal more with procedural matters. Now, the federal government, under the Supremacy Clause in Article 6 of the federal Constitution, can preempt a state legislature in several different ways. That which is not granted to the federal government, such as interstate commerce, etc., those are left to the states to do. And so, in reality, the scope of public policy making for the California legislature, as well as the legislatures of the other 49 states, is quite broad. There is one state, Nebraska, that's unicameral. Otherwise, California and 48 others have a bicameral legislature, meaning, of course, two houses. Like the lower house Congress, the U.S. House of Representatives, it's a larger body. We call it the Assembly. The California State Assembly, it has 80 members. The Senate, the so-called upper house, is similar to the U.S. Senate. It's a smaller body. Here it's half the membership. So 80 in the Assembly and 40 in the Senate. Each assembly district, each of the 80, is up for election every 2 years. Again, similar to the U.S. House of Representatives. However, unlike the U.S. Senate, which has 6-year terms, members of the California State Senate serve in 4-year terms. And as a result, one half of the Senate, 20 members, of course, half of the 40, are up for election every 2 years, which means the other half, 20 senators, are called carryover senators, meaning they carry over into the next 2-year session. Remember, with all 80 assembly members being at the end of their term every 2 years, all 80 are seated at the start of every new 2-year session. whereas at the start of every 2-year session, only half the Senate is that stood for election the prior month in November of the even numbered years. And so the other half are carried over. Some have, characterized the House, the lower house, the assembly, as larger, perhaps harder to maintain, more raucous body, as opposed to the Senate, which is often described as, of course, a smaller, perhaps more collegial body. Some describe the assembly as they do the House of Representatives, reflecting the priorities of a number of different smaller groups, whereas maybe the Senate is more likely to act as a body. Under the Constitution, a member of the legislature must be at least 18 years of age. Of course, the age to vote. They have to be a U.S. citizen as well. They do not have to be born in the state of California. Unlike members of Congress, California legislators have term limits. So the first term limits law was passed in 1990. It was Prop 140, sometimes referred to as the Shabaram Initiative. Then Los Angeles County Supervisor Pete Shabaram was behind it, and he specifically targeted the rule of then Speaker Willie Lewis Brown Jr., who had been the Speaker for the prior 10 years, 80 to 90. And then ultimately he was subjected to term limits and so left office in 1995, serving 15 years as Speaker and overall 30 years. No one can repeat that today. Under Prop 140, you had two significant provisions. The first was a 40% cut to the California state legislature's budget. So there was a substantial reduction in staff and also some additional bodies. For example, the Legislative Analyst Office, the LAO, akin to the federal CBO or Congressional Budget Office, used to analyze the fiscal impacts for all legislation and the budget. Due to their reduction in staffing after Prop 140's cut, the LAO only analyzes the California state budget. And the other item is that the Office of Legislative Counsel, the bill drafters and legal advisors to the legislature and governor for that matter, but not the other executive branch officers. The OLC, Office of Legislative Counsel, actually today is under the executive branch and is funded through the executive branch. Again, an effort to save most of that office from the Prop 140 cuts. The second part of Prop 140 was the imposition of term limits, 3 2-year terms in the Assembly for a total of 6 years, and 2 4-year terms or a maximum of 8 years in the Senate. Legislators did appeal to the California Supreme Court, which ultimately upheld the constitutionality of Prop 140 and also determined that that was a lifetime limit. So, for example, if a legislator sat out an election for 2 years, they couldn't get elected again for 3 2-year terms in the Assembly or 2 4-year terms in the Senate. Even if there was some time between their service, they were still subject to that maximum of 14 years between the two houses. There were efforts in 2010 and then ultimately successful in June 2012 to change the term limits law slightly. The voters adopted Prop 28, and now they changed it to a maximum service of 12 years in the legislature. Those 12 can be spent entirely in one house or in a combination of the two houses. And so that is the current term limits law today. So you could have someone serve 6 2-year terms in the assembly maximum, or 4-year terms in the Senate maximum amount in that house, or again, a combination between the two houses. Many commentators viewed the prior term limits law as particularly chaotic. Some described the 6-year maximum in the assembly as the first 2 years learning their way around the Capitol, the second 2 years actually conducting business, and the final 2 years running for some other office. Obviously, that was not said in a particularly complimentary way. Now, um, the proponents of Prop 28 in June of 2012 also argued and believed that folks would be uh, more likely to serve a maximum of 12 years, likely in a single house. That would allow them to develop greater expertise, that they would be more focused on the long term in policy making, because in 6 short years in the assembly, and perhaps that's the end of your legislative tenure, you probably are not looking much beyond those 6 years. So many emphasize that with a maximum of 12 years in the legislature, particularly in one house, that legislators would be more likely to look long term. They also argued that it would probably result in more legislators conducting oversight and pursuing that role, not just lawmaking. We had the first batch of 12-year term members in 2024. Again, the first group were elected in November of 2012. And so they had the maximum 12 years in 2024. What we found was less than 1/3 of the original 12-year members actually made it for the full 12 years. Some of them pursued federal office, some pursued local office, some left to the private sector, some took other jobs in the public sector. For example, somebody was named city attorney, another was made a superior court judge, etc. But those beliefs or arguments for the potential benefit of 12-year terms and the passage of Prop 28 have so far not really borne out, particularly members staying for the full 12-year term. So we have not seen that. Again, up to 1990, there were no term limits. One of the oldest serving members who termed out in the 1990s was Senator Ralph Dills, a Democrat from Gardena in the Los Angeles area, who served for 40 years. Prior to term limits, you generally had members of the legislature who started off in local office, would get elected to the assembly, and then when a Senate seat opened up, they would graduate, if you will, up to the state Senate, and then potentially on to a federal office, for example. Some described at those times prior to term limits, the assembly being typically younger individuals, less experience, a faster pace, with the Senate membership generally being older in age and a little slower paced. However, now with the maximum of 12 years, regardless of House, there's a little less jumping between the Assembly and Senate. Now, members will get elected directly to the Senate without any prior service in the state assembly, for example. There's also a larger number of younger individuals. In recent years, we had somebody as young as 25 be elected, which was almost unheard of prior to term limits, and several others in their late 20s and 30 years of age as well. The legislature, I think, historically has produced a high volume of work. It wasn't until the late 1990s that um, a bill limit was imposed. To get a sense, the legislature has adopted 29 codes where they have more than 150,000 individual statutes that are contained in those codes, beginning with the business and professions and ending in welfare and institutions with things like the evidence code and health and safety and government code and code of civil procedure and streets and highways, etc., all in between. So the legislature has adopted a significant number of statutes over the years and adds anywhere from 7 to 900, upwards of 1,000 new laws each and every year. The legislature, of course, also interacts with the federal government as well as local governments. Local governments, as you may recall, um, back in the first actual class session, they are deemed political subdivisions of the state, our 58 counties, but also our legislature, and they can preempt um, county and city governments, just like the Congress, the federal government can, in some limited areas, preempt state laws. But our legislature, of course, interacts with the federal government. The most formal way is ratification of amendments to the US Constitution that are proposed by the Congress. If I recall, it's about 27 or 29 amendments to the federal Constitution. Generally, Congress can't require a state to enact a particular law or to enforce certain federal programs. That's left to the federal government. Of course, as we know, Congress has certain ways of encouraging the states to cooperate. The most common way, of course, is conditioning the receipt of federal budget funding on on the states, right? For example, we had 21 being made the legal age for the consumption of alcohol in an effort to secure federal highway funding. Ultimately, the in Article 4, we talked about it before in the first session, where the governor has specified roles, primarily the budget and consideration of legislation. Interestingly, though, these are actually contained in Article 4, the legislative branch of government, as opposed to Article 5, dealing with the executive branch of government. There are a number of other powers of the legislature. Again, as I mentioned, things like investigation and oversight, particularly of executive branch departments and agencies and boards and commissions. Similar to the US Senate, they also confirm a number of gubernatorial appointees. The main one, as you may recall from an earlier election on the judicial branch of government, a separate commission, the Jenny Commission, evaluates gubernatorial appointments to the bench, to the judiciary. So that is a major distinction between the California State Senate and the US Senate, where the president's appointments of federal judges, district court, court of appeal, and the Supreme Court are confirmed by the US Senate. That does not occur in the California legislature. The legislature, in its ability to hold, investigatory or oversight hearings, they also have subpoena power. Those are generally run through the respective rules committee of the Assembly and Senate. They also have a number of support entities that we'll get into. Most of the appointments that the Senate confirms are by majority vote. There are a very small handful of 2/3. The only instance where the assembly also is involved in confirmation is when it comes to other constitutional officers being appointed. So whereas if there's a vacancy in the legislature, in the assembly, or the Senate, per the Constitution, the governor must immediately, which we've defined in the in the elections code as 14 days, must immediately call a special election to replace the assembly member or senator for that vacant seat. For the constitutional offices, for governor, the lieutenant governor by the Constitution fills that seat. But everybody else, the governor can appoint a replacement. Governor Newsom, prior to 2024, did that for two officials, the Secretary of State, former Assembly Member Shirley Weber, and Attorney General, former Assembly Member Rob Bonta. Both of them since then ran for election to their own 4-year term in 2024. But those didn't require, they gave the opportunity to the Assembly and Senate. Essentially, what the Constitution provides is that neither house can vote to not confirm. So they can both vote to confirm, which they generally do. However, if they don't reject the confirmation, then those individuals are automatically confirmed. Lastly, right here, the legislature, similar to the federal Congress, has authority to impeach uh, the 9 constitutional officers as well as judges of the state court only for misconduct in office. So that is the stated basis for impeachment. Again, members of the executive branch, the constitutional officers, and judges of the state courts. Note again that judges can also, and constitutional officers can also be recalled by the people, and that judges also are subjected every 12 years to a retention election. Impeachment by the legislature is similar in process to what the federal government does, the U.S. Congress. That is, the Assembly impeaches and the Senate has the trial and removes from office one of those officials. And obviously, it's a two-step process. Even though somebody may be impeached by the Assembly, it doesn't mean that they lose their office. The Senate has to try that person and vote to convict by at least a 2/3 vote in order to remove that official from office. Legislators are regulated, as you can probably imagine, in their official conduct. They are prohibited under the Constitution from accepting any honorarium. That means that they can't accept a payment for giving a speech, taking a tour, making a public appearance, writing an article. So prior to that prohibition, which the voters added to our Constitution, there were stories about legislators who literally showed up and gave a 5-minute speech and received a payment from, say, an interest group or something like that. So today, there's an absolute prohibition. There's also a limitation on gifts, but the Constitution grants to the legislature the authority to determine what constitutes a gift and how much those amounts are. There are limitations on lobbyists and lobbyist employers. You may recall from a prior session, a lobbyist or lobbying firm is limited to $10 per calendar month for a gift. Today, a lobbyist employer, because their amount, which began at $250, it's now about $620 per calendar year. The lobbyist employer gift limit is subject to a cost of living adjustment. The lobbyist or lobbying firm $10 gift is not subject to any sort of CPI. There's also extensive definitions in the Legislative Code of Ethics in our government code. That's a statute, of course. There are definitions of what does and does not constitute a gift and who may give them, and subject to certain disclosures, et cetera, et cetera. There are also extensive conflict of interest laws in the state constitution. In general, legislators are prohibited from accepting any sort of compensation from a lobbyist or lobbying firm, what you would probably expect. They also are prohibited from either introducing legislation or voting on what is called non-general legislation. In fact, they can't even participate in um, making decisions or utilizing their position as an elected official to influence any sort of state governmental decisions of the legislative or executive branches in which they have some sort of financial interest in that decision. Non-general legislation means general legislation, of course, is it applies to everybody. Non-general, it's very rarely is considered for obvious reasons. No one wants to be in a conflict of interest type situation, but in theory, where somebody could um, be personally impacted themselves as opposed to the general public. So, for example, there's nothing wrong with a somebody who is a licensed insurance agent and who, had a insurance business prior to being elected to the legislature to author legislation dealing with the insurance code and legislation impacting insurance agents, as long as all insurance agents are affected in the same exact manner. In other words, that there's not any particular benefit to this individual legislator himself or herself. The legislators also have to make disclosures when they assume their office, when they leave their office, and every year in January. They file what's called a Form 700 with the FPPC and Secretary of State. It's formally the SEI, or Statement of Economic Interests. And the purpose of that is for legislators to set forth um, financial interest, property they own, um, shares of, companies that they own, other financial information in which it could create a potential legal conflict of interest for them. It's also where they disclose the gifts that they've received over the past calendar year. And that is why, for example, every year there's an article or multiple articles written by, for example, Capitol Press Corps members describing, official trips that legislators took, or, how many received tickets to a ball game or the Super Bowl, the Academy Awards, etc. It's not that they dug this information up. It is filed electronically each year. And so the press corps and the members of the public, for that matter, of course, can review the Form 700. This applies to not only our legislators, but also the constitutional officers and also local government officials as well are also required to file SEIs because they too are subject to conflict of interest laws. Legislators themselves, not their staff, but legislators, the assembly members and senators, are subject to the same 1 year, 12-month revolving door restriction that applies to the executive branch. Of course, the difference with the executive branch is it's not just the constitutional officers from the governor on down, but it's also agency secretaries and undersecretaries and deputies and department directors and chief deputies and deputy directors and all those types of folks. Again, it's only applicable to the 120 legislators and not their staff. The revolving door, of course, is a prohibition on being compensated as a lobbyist to lobby the legislature or any legislative official or legislative employee. And it lasts 1 year from when they leave office. Two things. After a number of high-profile legislators leaving office before the end of their term and taking a lobbying or government relations type job, the legislature actually amended the statute. And the 1 year prohibition is in the Constitution. The legislature can add to it in statute, and that they did. So now what the law says is if you resign, if you leave office before your scheduled end of term, which is November 30th of the even numbered year, then that gets tacked on to the 1 year. So say, for example, you're 1 year into a 2 year assembly term and you leave office. The revolving door begins when you leave office for the year until your term ends, and then the 1 year constitutional term. So in that example, it would actually be a 2 year prohibition rather than one. And as you can probably expect, the legislature did that with the idea of trying to make early departure less attractive. It doesn't mean folks haven't done it, but that is, a limitation, at least on your ability to be compensated for any potential lobbying activity. So that's an important, notation when it comes to the revolving door. There are a number of uh, support offices, if you will, that work with the legislature itself. I think the two main ones are ones that I've mentioned, the Office of Legislative Counsel. Every 2 years, the Assembly and Senate vote, they adopt a resolution naming the Legislative Counsel. The past few years, it continues to be Kara Jenkins. And so she is the Legislative Counsel. And then there are about 80, 85 deputy Legislative Counsel. Those are the attorneys that work in the Legislative Counsel Bureau, drafting bills and amendments, providing verbal and written advice, including, an opinions unit, etc. So they primarily, of course, draft legislative measures, but they also provide legal opinions. We have a rule that legislation can neither be introduced nor amended unless those bills or amendments are in what we call legislative council form, which we'll talk about in a later lecture on legislative drafting. The other main one is the Legislative Analyst Office, or the LAO. And the legislative analyst is also appointed by the legislature and is intended to provide nonpartisan budget advice, fiscal information, essentially the counterpart of the governor's Department of Finance. So while DOF or finance advises the governor about the budget from the executive branch side, the legislature has its equivalent of the CBO, the Congressional Budget Office, which is the LAO. We also have a Bureau of State Audits, BSA, or the state auditor. And the state auditor is an individual and then has, of course, a number of deputies and staff who perform the actual audits. And those independent audits, financial audits, or performance-based audits are either set forth in statute or in most instances they are adopted by by JLAC, which is the acronym JLAC, or Joint Legislative Audit Committee, which is made up of an equal number of assembly members and senators. And so those are, of course, the audits that are authorized by the legislature itself. So I think those are the key areas in terms of support branches for the legislature. Remember again about our hierarchy of laws, the Constitution, the statutes. We don't have any regulations applicable to the legislature because what they do is adopt statutes and then they adopt by resolution their joint rules and their individual house rules, and then committees themselves adopt rules. And so the legislature itself is governed, of course, in terms of its role as an institution and the process that it utilizes in adopting legislation is all done again by way of the laws, the Constitution, the statutes, and their internal rules. They have a number of publications, only one of which is required by the Constitution. That's the Daily Journal, sort of a record of the legislative proceedings. However, it is vastly different than if you've ever seen the Congressional Record. The Congressional Record is basically a verbatim transcript of congressional proceedings. The Assembly Daily Journal and the Senate Daily Journal, so there's one for each house. Those are um, just broad things. They do have votes, but they don't have, for example, who are the speakers for and against a bill, or what their names are, or what they actually said. Again, there's no verbatim transcript. Yes, our committee hearings and floor sessions are all subject to video and audio recording and are placed on the websites of the Assembly and the Senate. I just wanted to run through now the major provisions of Article 1, I'm sorry, of Article 4, the legislative branch. In Section 1, the legislative power is vested in the legislature, which consists of the Senate and Assembly, which we know an important provision that was added by the voters, but the people reserved to themselves the powers of initiative and referendum. So, as opposed to the executive branch, which grants the supreme executive power to the governor, and then mentions several of the other constitutional officers, statewide officials, in Article 5, Section 1, and Article 6, Section 1, it gives the judicial authority to the Supreme Court and the lower courts themselves. But in the legislative branch of government, the legislature and the people share the lawmaking powers. And so, of course, we had talked about initiative and referendum. Initiative is the way for the voters to make laws, either in the Constitution or by statute and statutory initiatives, or by referendum to overturn a statute that was adopted by the legislature and governor. So we share the law, we the people, the voters share the power of lawmaking with the legislature. The next one is, as I've mentioned in Section 2, 40 members of the Senate, 4-year terms. It actually says 20 to begin every 2 years, and the Assembly with 80 members, 2-year terms. Their terms start on the first Monday in December following their election the prior month, the first Tuesday in November. And so that first Monday of the even numbered year, they commence the 2-year session. What's interesting is it takes the following year's number. So, for example, even though the first Monday in December of 2024, following the November election, they convene the new 2-year session, it's actually referred to as the 2025-26 session. Again, technically, it began, I think that first Monday was December 5th of 2024. They also here in Section 2 is the 12-year term limit. Again, it says no more than 12 years in the Senate, the Assembly, or both in any combination of terms. This was also prospective in application. The first time the legislature placed a revised term limits law again after 1990 and Prop 140 was in 2010. They tried to make it retroactive, i.e., capture the people who are currently in office. That was unsuccessful. The voters voted it down. And so in June of 2012, again, the same 12-year limit, though, they said it's prospective only. The voters adopted that version of it. The um, Again, you have to be a registered voter and a resident of the legislative district for the past year, as well as a U.S. citizen, a resident of California for 3 years preceding the election. Note that some of these residency requirements, such as being in the district, um, have been struck down in other states. So there's a question whether or not this would be applicable. In section 2, you also have the provision that I mentioned: when a vacancy occurs, the governor shall immediately call an election to fill that vacancy. Again, we've defined in the government code immediately means within 14 days. In section 3, we have the convening of the regular session, again, which is noon the first Monday in December. The first order of business is that they have to organize their session. And that means, of course, that they swear everybody in, they elect their leaders, they adopt their rules, and then generally they go away for a month and reconvene in January for that first or odd numbered year of the session. We also have what we call adjournment sine die, which is Latin for without days. It basically means that at the end of November 30th of the following even numbered year, so remember they start the first Monday at noon in December, just shy of 2 years later, November 30th, they adjourn sine die, which means that 2-year session is at an end. Section 3 is also where special sessions are authorized. The formal term is extraordinary session. So in documents, on bills, in the daily journal, the daily file, it will reference an extraordinary session. Everybody refers to them in special session as special session. Either is proper. Why? In 3B, it uses both terms. On extraordinary occasions, the governor by proclamation may cause the legislature to assemble in special session. Now, the legislature is limited to legislating on matters under the call. What's in that proclamation? They do not have to adopt anything. So they have to, most people believe, although it's not clearly specified, but whether you had a Republican governor and a Democratic legislature or vice versa, the legislature has always viewed itself as having to convene a special session when the governor proclaims one, but they actually are not required to adopt any legislation in it, and they can promptly adjourn the special session. Section 4 deals with all of the ethics rules, the conflict of interest, the revolving door, um, the the gifts and honoraria. There's also provisions about travel and living expenses. Today, the legislature, you can't get paid if the legislature is in recess for more than 3 days. So they meet Monday through Thursday, and then Friday, Saturday, and Sunday they're in their district. That's 3 calendar days, and then they reconvene on Monday, and therefore they're paid per diem or their travel and living expenses for 7 days a week while they are in session, unless for some reason they decline or they are not conducting legislative business, in which case they're prohibited from doing so. Part of Prop 140 eliminated any sort of pension for legislators. So, although they get Social Security, they are prohibited after 1990 from getting any sort of pension. So they don't pay into one. The state doesn't provide them one. In section 5, this is where the legislature judges the qualifications and the election of its members, not the executive branch and not even the judiciary. In a case involving former legislator Tom Hayden, yes, the same Tom Hayden married to actress Jane Fonda, etc. There was an effort to, because of his alleged, anti-Vietnam War activities, that he was not entitled to be seated. Um, the California Supreme Court basically said that the legislature is the sole judge of qualifications. And of course, Section 5A1 says each house of the legislature shall judge the qualifications and elections of its members. So the text is pretty clear. And so the Cal Supreme Court said, nope, the 80 members of the Assembly and the 40 members of the Senate get to decide who sits and who doesn't sit. They also have the authority to expel a member by a 2/3 vote. The other thing is about a decade ago when 3 members of the California State Senate were under federal indictment. No, one was state, the other 2 were federal. Um, the legislature recognized that they really didn't have any authority to preclude these folks from conducting business or receiving a paycheck if they didn't voluntarily step down or resign their office. And so the legislature placed a measure before the voters, and the voters approved it, adding some language to Section 5 of Article 4 that the legislature by 2/3 vote may suspend a member. Now, it has to have basically a written motion or resolution specifying why they're being suspended, but it also allows for the salary not to be paid to those who are suspended. And so that's an important feature. So they can both expel or suspend a member. This is where in B, no member of the legislature may accept any honorarium. And then in C, the legislature shall enact laws that ban or strictly limit the acceptance of a gift by a member of the legislature. Also of interest here is that legislators cannot do generally what you would expect them to potentially do for constituents. So they can't be paid for appearing or taking action on behalf of somebody before a state government board or agency. So the fact that a legislator, sends a letter to an executive branch department asking them to do something, or perhaps even acting on, for example, somebody's licensure application or something with like the Department of Consumer Affairs, they can't be compensated for that. Generally would, I think, make sense to most people because they're being compensated as, a legislator themselves, right? The revolving door, the lobbying ban for 1 year took effect back in 1990, by the way, just to be aware of. In Section 6, the state is divided into 40 senatorial districts and 80 assembly districts. And as you would expect, stating the obvious, each district chooses 1 senator for a Senate district and 1 assembly member for an assembly district. Going back to those rules, joint rules apply to both houses, Senate rules and assembly rules. That is because in Section 7A, it says each house shall choose its officers and adopt rules for its proceedings. So it has the constitutional power to adopt those rules. And then it also says that a quorum is a majority of the member of the assembly or the Senate. This is also where the journal is required. So the daily file, which is basically where they lists all the committee hearings and the bills that are on the floor of the Assembly and Senate. There's a Senate daily file and Assembly daily file, as well as weekly histories of the Assembly and Senate. Those they do of their own volition, if you will. It's only the journal that is constitutionally required. There's also provisions here stating that proceedings of the Assembly and Senate, when they meet as a body, as well as all their committees, have to be open and public, and that the public actually has a right to attend all of their proceedings. The legislature can adopt reasonable rules regulating the use of recording equipment, but that's it. And you can actually go to court. Individuals actually have the authority to bring a lawsuit if they can demonstrate that the legislature isn't acting reasonably. There's also the requirement that the legislature do audio and visual recordings. These began in 2017. So every assembly committee and floor session and Senate committee and floor session is available on their websites. They have to post them within 24 hours after they finish the hearing or the floor session, and they actually have to maintain them on the internet for a minimum of 2 decades. This is also the section where closed sessions are allowed. So we have in subdivision C that everything has to be open in public, and the public has a right to attend those hearings and floor sessions. However, there are 4 instances where the legislature may meet in closed session, and the first 3 may sound like local governments as well. Employee, things, evaluation, appointment or dismissal of public officers or employees is one. Safety and security is a second one. And then to confer with legal counsel is the third main one. There's also a fourth. So when the members of the Democratic and Republican parties in the Assembly and or the Senate want to meet, they can do so in closed session away from the public. And that is specifically granted to them in the Constitution itself. And then the remainder, for the most part, of Article 4 is dealing with procedural matters. And so we'll get into the process stuff at our next lecture. So that's a broad overview of the California legislature. Again, its constitutional underpinnings, some of the information related to its support offices in the legislative branches and how they're elected and serve, et cetera, and where they have their authority. Again, I think most legal observers describe the California Constitution. They describe the federal Constitution as well as one granting specific powers to the Congress. In other words, the Congress can only enact legislation under the items that are specified in Article 1 of the U.S. Constitution. Legal scholars view the California Constitution and the Cal Supreme Court has stated on occasion that the state constitution is a limitation on the powers of the legislature. So, in other words, if there isn't a specific prohibition on them doing something, then generally they can act. Of course, it has to conform to the U.S. Constitution, the state constitution, and federal statutes, but otherwise they have a wide amount of power. Any questions? If not, we'll see you later in the week.
Chris, point of clarification, did you say to date there has not been an elected official who's gone the full 12 years? Is that correct?
Sorry, say again?
Is it correct that there's to date there's not been an official that's gone the full 12 years?
Oh, no, about a third of those who were elected in 2012 served the full 12 years, but about 2/3 of them did not.
Gotcha. Cool. Thanks.
Yeah. All right, we'll talk soon, later in the week about legislative process. Thanks for joining.